My name is Erica Barnes, and I'm an attorney on the Compliance and Investigations team at Maynard Nexsen. I advise individuals and businesses on how to navigate government investigations, whether as witnesses, victims, or targets. One of the most common requests I get from clients is how to handle grand jury subpoenas. Any kind of business or individual may receive a grand jury subpoena. These subpoenas can be benign requests for information, or they can be the canary in the coal mine signaling that you or your company is under investigation for criminal offenses. So how should you approach such a potentially loaded request? First, you must know what you're dealing with. A grand jury subpoena is not a traditional subpoena in a civil lawsuit. Difference 1, who are you dealing with? A grand jury subpoena is issued by a prosecutor acting on behalf of the state or the United States, not a lawyer representing a private party in a lawsuit. When you're negotiating over a grand jury subpoena, you must remember you're negotiating with the government and a lawyer who has the authority to file criminal charges. Difference 2, what don't you know? Unlike a civil subpoena, which seeks evidence to be used in a publicly filed lawsuit with known litigants and causes of action, a grand jury subpoena is secretly seeking information to help determine whether an undisclosed person or business committed an undisclosed crime. So you're responding to the unknown. You could be providing evidence to help the government get the bad guy, or you could be providing evidence against yourself. You may simply need to provide documents, or you may need to prepare to be investigated. What about difference 3, the rules? Grand jury subpoenas are issued under the rules of criminal, not civil procedure. That means there's a different process and more limited grounds to object to them. A recipient can't simply object on common grounds like relevance. There also may be different consequences for failing to comply. And finally, there are secrecy rules that can limit your ability to discuss or share grand jury subpoenas. So second, you know what you're dealing with. Now you should seek experienced counsel to review the subpoena and make contact with the prosecutor before you respond. Counsel can try to determine the scope of the grand jury's investigation and your role in it. Even if the subpoena turns out to be a benign request for information, experienced counsel can often save you time and money by limiting the scope of the request and extending the time to comply. Counsel can also save you heartache by ensuring that you're not accused of violating grand jury secrecy or obstructing justice because of the manner of your response. If you or your business needs assistance with these types of matters, please reach out to us today.